Hello and welcome to this first affidavit of accusation for the MBA Law Services that is being published to our YouTube law channel and is made available to any member of the public who wishes to read it or listen to it. What we are doing is we are working on the reintroduction of the rule of law across the Western English-speaking world. We have first decided to start with Australia and Ireland. However, William Greathouse was recently slandered and removed from his job based on the crime of slander. So the slander itself was a crime, and the removal from his job based on slander was further injury, harm and loss caused as a result of a crime. We have now managed to gather up evidence that this slander took place, namely the management company, represented by a woman called Amber, said so on a teleconference with a government agent who is responsible for the unemployment benefit that William was applying for. It is extremely unlikely that this woman, named Amber, would lie to a government agent as to why a man was dismissed from his job in the discussion about welfare. Okay, so we believe that Amber was telling the truth, and we believe that the evidence of the audio recording of that conversation is certainly sufficient evidence to know that Bill was slandered and that he was fired for that slander. Jody Mohn is the general manager for the Sheldon Holiday Inn Express. As the general manager, it is not credible that she was not involved in Bill's dismissal, since Bill worked for her. Given that Amber, who was the woman that Jody Mohn must have spoken to about Bill, claimed that there were numerous staff who said that they were uncomfortable about working with Bill, and she herself claimed that Bill had condoned and supported killing women and leaving them dead in a ditch, and she herself claimed that she had performed an investigation into Bill's YouTube channel, and she herself claimed that the police were called over this issue. There can be no doubt that some of Bill's colleagues slandered him, that this slander was taken to Jody Mohn and then further taken to Amber, and that this slander about what Bill had allegedly said was used to dismiss him. That is our contention. That is what Bill has agreed to put on an affidavit under oath. I have assisted him in this process of creating this affidavit. Bill is a handyman, not a lawyer, and so he has no experience of common law. He has no experience of affidavits, and so I am representing Bill in this situation. The video you are about to watch is the affidavit that Bill has signed and had witnessed and has presented to Jody Mohn, and we are presenting it in the public. Now, for those of you who do not understand how this works, these are accusations and statements made under oath and penalty of perjury and full commercial liability, where Bill believes these statements to be true, and the audio recording of Amber is the evidence that is necessary to have that stand up in a court of law. Jody Mohn has a number of options open to her. If she stays silent, she accepts Bill's accusations and accepts her guilt. If she stays silent past the 19th of April, then I shall issue a default judgment of guilty against Jody Mohn, and the $20,000 that is the proposed remedy payment will be used to place a lien against her property. Okay, she will then have an official debt of $20,000 to William Greathouse if she fails to respond by April the 19th, because in common law silence is consent, and if you do not respond to an affidavit served in public like this, then you are agreeing with what is on the affidavit. Now, Jody Mohn, if she contests these accusations, the way that she does that is she writes out her own affidavit, and she, point by point, and there's about 27 points, rebuts what Bill has to say. Now, she's to rebut what Bill has to say, she's going to have to say, under oath and penalty of perjury, that Bill has condoned and supported the killing of women and leaving them dead in a ditch, and that he has promoted such. She is going to have to claim that he has done such, and then she's going to have to prove that he has done such. Okay? She is going to have to prove that the women who slandered Bill had good cause to feel uncomfortable about him, rather than they were pretending to feel uncomfortable about him. Okay? Jody is going to have to prove that Bill was dismissed based on factual statements, not based on slander. Okay? Now, I've known Bill for a number of years, and I've known people who've known him for a very long time. And should this go to trial, I am sure that we can put up any number of witnesses who will testify to Bill's character, and who watch Bill's videos and listen to what Bill has to say, and will testify that Bill has never at any time supported and condoned killing or injuring anybody. Okay? What he has said is those people who endlessly torment people and cause a great deal of drama in their life, if that backfires on them and the person they've been tormenting and criminally victimizes causes them injury, harm or loss, then they brought that on themselves, rather like poking a dog with a sharp stick. If you poke a dog with a sharp stick and irritate the dog and the dog bites you, nobody blames the dog. You deserve to be bitten. If you go and irritate a dog, you deserve to be bitten by the dog. Similarly, Bill's contention is, if you irritate men, criminally victimize them over an extended period of time and give them no path to justice, you deserve it when they react. That's his contention. And his advice for many years has been, stop criminally victimizing men because you are making them angry, and they are responding in larger and larger numbers. And if you stop criminally victimizing them, you will reduce the amount of violence against women and children by angry, often suicidal men. And I can put any number of men on the stand who will testify that is what Bill has been saying for a long, long time, and that anybody who listened to any significant amount of what Bill has said will come to realize that he is a man of great love and compassion for his fellow man, and he is not a man who condones killing women, quote, killing women and leaving them dead in a ditch, unquote, and could never be characterized as such honestly. Okay? So that is our contention. This video is now being put into the public. The public can also watch this trial process to ensure that they feel the due process of law has been properly completed. Okay? We are working to reintroduce the rule of law, and we are using due process of law to make sure that anybody who questions what it is that we are doing has available to them all possible evidence, the same evidence that would be presented to jury members, to ensure that they feel that the due process of law was performed and that all parties were treated as equal before the law. That is what we are doing. And now, without further ado, I will start the video of the reading of the affidavit. Thank you very much for listening. This is a reading into the public record which can be presented to a court of law for adjudication of an affidavit sworn under oath and penalty of perjury from one William Greathouse, directed to Jody Mohn. What this will be is a simple, direct reading of this document for those people who wish to hear oral testimony as opposed to sitting down and reading a document for themselves. Should this case go to the MBA Law Services and to the MBA courts, this reading will be presented as evidence into that court. Any other further rebuttals from this reading will also be entered as evidence into that court. From the free man commonly called William Greathouse, standing in God's kingdom, in care of Instant Business Intelligence, 17 CA Rossetti, 2nd District, Bucharest, Romania, fax number and email address supplied. 2. The lawful notice is to the respondent, the woman calling herself Jody Mohn, also known as Ms. Jody Mohn, General Manager, Holiday Inn Express, 201 34th Avenue, Sheldon, Iowa, 51201, fax number supplied, 27th of March 2013. Explanatory notes. To the woman calling herself Jody Mohn. Dear Jody, this section is written by myself, Peter Andrew Nolan. The purpose of this section is to make clear to you your current position at law. I have no obligation to tell you this, but I thought I would explain this to you since any lawyer you hire is likely to lie to you as to your current position. I have also included some explanatory notes to make it clear why I am prosecuting you for your crimes. You were politely and professionally asked to give me any and all information you are aware of with respect to the dismissal of William Greathouse. As a general manager of the Sheldon Holiday Inn Express, you must have been directly involved in his dismissal. Any claim you were not directly involved in his dismissal is not credible, and no jury of 12 men would believe any such claim. You chose to refuse to provide me with information I requested, as was your lawful obligation. When you are a witness to a crime, you have an obligation at law to present any and all evidence you have to any authorized person. I was such an authorized person, as I am the representative of William in this matter. Your refusal to hand over your testimony when professionally and politely asked made you an accessory to the crime you witnessed. It is called accessory after the fact. From the telephone call between William, Amber and the publicly unnamed man, it would seem that you were also an accessory during the commissioning of the crime of slander and the subsequent unlawful dismissal of William from his place of employment. It is up to you whether you confess being an accessory during the commissioning of the crime or merely an accessory after the fact. It makes no difference at law, as an accessory after the fact is subject to the same remedy instruction as an accessory during the commissioning of a crime. William Greathouse denies ever condoning, quote, killing women and leaving them dead in a ditch, unquote. No evidence has been presented that he has ever condoned such behaviour. Further, for many years, William has been a fearless crusader for truth, justice, liberty and equality before the law. William Greathouse has great love and care in his heart for his fellow people, men and women alike. He has been warning women for years and years that their willingness to commit crimes against men, and to do so behind the impunity offered by the criminals in the so-called legal system, is actually the cause of the rapidly increasing rate of men murdering women. William has been warning women that their endless crimes against men and avoiding justice and making remedy to those men for the crimes they commit will result in more women being, quote, killed and left dead in a ditch, unquote. In effect, he is advising women to the effect that there would be less violence against women should they take his advice. And that advice is simple: hold women accountable for their crimes on an equal before the law basis to men. I too have been warning women for more than 5 years that I have seen a rapid increase in violence against women because women commit crimes against men with complete impunity. In my case, my ex-wife, Jennifer, committed the crimes of perjury, kidnapping, extortion, theft and child abuse, and I was so affected by these crimes I was suicidal for a month. Many men in similar positions are suicidal for years. I have been advising women that driving men to the edge of suicide is very dangerous, because a man who is suicidal might just kill those who are tormenting him, just like a tormented dog might bite the person tormenting it. If you torment a dog by poking it with a stick and the dog bites you, no one blames the dog. They blame the person who torments the dog. We even call it a crime. It has the name animal cruelty, and some people even go to jail for committing this crime. A very notable such man was Michael Vick, a quarterback in the NFL. He went to jail for some time for, quote, animal cruelty, unquote. However, if a woman torments a man to the edge of suicide by stealing his children, using them as weapons against him, stealing his house, his car, his cash, and a good part of his future income, all based on the crime of perjury, and he lashes out and kills the woman, everyone blames the man. Such endless abuse is never called cruelty, despite the fact that is exactly what it is. It is no exaggeration to say that men are treated as less than dogs when it comes to the protection of the law on the land known as Iowa. No one ever looks at what the woman did to torment the man. Men like me have been warning women to stop tormenting men, stop abusing them, and to hold criminal women accountable for their crimes, or the inevitable result will be more women and children killed by angry men, often suicidal men, tormented beyond their endurance. The proof that men like William and I were correct in our warnings over the years is in the newspapers every day. Virtually every day of the week you can see a news story about a man in a divorce killing his ex-wife, and more often that story includes a man killing his children. The fact that men like William and I are warning that this increase in violence by tormented, often suicidal men is the inevitable result of women not being held accountable for their crimes is, in caps, not the same as condoning those crimes. You are well enough intelligent to know that. For my part, I have actually claimed into existence a state of war on the land known as Ireland. I have had to take this very undesirable step to make it clear that women and the legal fraternity in Ireland are prosecuting a war against men. I have called for the women of Ireland to cease and desist this war on men for more than 5 years. In the face of the refusal of women to cease and desist committing crimes against men and being given impunity by the legal fraternity, in the face of the refusal of even 12 men on the land known as Ireland to form a properly convened court of law, the only step left was to claim into existence a state of war. At this very moment, it is just as lawful for a man to commit an act of war against an adult non-Muslim woman on the land known as Ireland as it is for a woman to commit perjury in the family courts and to steal from the man. The emphasis equally lawful. It is a disgrace on Irish women that it has come to this. However, they are very adamant that they want to commit crimes against men with total impunity, and they have refused all efforts to enter into dialogue on this issue. It is very telling of our women that they can openly mock and laugh at and abuse men who have been the victims of crimes by women, but be, quote, upset, unquote, when a man claims into existence a state of war so as to make lawful self-defense that includes the use of force and violence. The same sort of force and violence that women wield by proxy every day when they, quote, call the police, unquote, based on false allegations. In William's case, the police were called based on the slander and false allegations of your staff. I have personally been the subject of a false allegation made by my wife, and she called the police. I was assaulted, severely injured, incarcerated, and could have contracted a life-threatening disease from my cellmate who was covered in blood. This is the sort of violence and force that us men are commonly subjected to based on nothing more than a false allegation by a woman. Even our own wives do this to us, and they are supposed to, quote, love and honour, unquote, us. This is a disgrace, and you know it. Since women are quite happy to prosecute a war on men that includes violence and force that is life-threatening, they can have no complaint when, quote, when on refusing to cease and desist such a war on men for more than 5 years of being asked to do so, those very men they wage their war on finally decide enough is enough and claim into existence a state of war in return. To date, no such state of war has been claimed into existence on the land known as Iowa, but it is very possible it might happen if women exactly like yourself continue to criminally victimize men and then hide behind the criminals in the legal fraternity to get away with your crimes. One of the favourite crimes women like to commit against men nowadays is the crime of slander, exactly the same crime committed against William. Women will commonly commit the crime of slander to cause injury, harm and loss to a man and then hide behind the criminals in the legal system that the women know full well will not prosecute them. Indeed, in the family courts, the crime of slander will usually get the woman the house, the cash, the cars and a large slice of the man's future income. It is a disgrace, and you know it. The vast majority of women know that women commit the crime of slander every day in the family courts, and your silence on this matter is considered consent and condoning of the crime of slander, presented as no less than perjury. There is not a woman over the age of 30 in the USA who does not know women lie under oath in the family courts to get more money from the man, yet there is barely a woman to be found in the USA who will call this a crime of perjury that it is and demand that women are held accountable for her slander and perjury. Men like William and I are looking to put an end to the practice of women committing crimes with complete impunity. We are working at this for the very reason that unless women stop committing such massive levels of crimes against men with complete impunity, more and more women and children are going to be killed by tormented, often suicidal men. By the way, no one cares when men are killing themselves in their tens of thousands based on the crimes of women. According to our women, men killing themselves and being, quote, dead in a ditch, unquote, is perfectly okay. The very false claim you make against William is a behaviour virtually every woman in the Western world indulges in daily, that being the condoning abuse of men and the murder by proxy of men, and then completely indifferent to men being murdered by proxy by women. That behaviour is exhibited every day by virtually every woman in the Western English-speaking world. It does not look so pretty when your own indifference to, quote, men being dead in a ditch, unquote, is reflected back at you, does it? The evidence that William can present that he has been doing the very opposite of what he was accused of is overwhelming. William can call on any one of hundreds and hundreds of men who will testify on his behalf that he has been risking his life so as to reduce the level of violence we see reported in our newspapers and on TV every day. Any jury of 12 men are going to unanimously agree, beyond all doubt, that William is a loving, kind, caring man who has risked his life for the benefit of others. That our women, and many men, openly insist that women be allowed to commit such crimes as perjury and slander is a disgrace on those who do so. Those who openly insist women must be allowed to commit crimes as slander and perjury are very displeased when this is pointed out, and their first response is usually to commit the very crimes of slander and even perjury, just as men like William and I pointed out they do. How about that? Your position is now this. William can prove, beyond all doubt, that he was dismissed based on slander. The phone call by Amber clearly makes reference to, quote, women being dead in a ditch, unquote, and clearly slanders William by pretending that he has condoned such behaviour. Amber clearly states that this was the basis of the complaints made against William, and clearly states that this was the cause of his dismissal. In effect, Amber has provided us with the irrefutable evidence that the crime of slander took place, and that this crime of slander resulted in William's dismissal. This is how the jury will see it if we are forced to create one. You were very well advised to offer us that evidence and not force us to collect it for ourselves. You, being the general manager, could not possibly have not been a witness to this slander and could not possibly have not known that William's dismissal was unlawful because it was based on the crime of slander of as yet unnamed co-workers. That you will be found guilty of the two crimes of which you now stand accused is a foregone conclusion. My advice to you now is this. Admit your crimes rather than commit the further crime of perjury by attempting to lie on an affidavit of reply. The way to rebut William's affidavit of accusation is to create an affidavit of reply and respond point for point to the statements made by William. Any lawyer can tell you that in common law, silence is consent, and to refuse to rebut an item on an affidavit of accusation is to accept that it is true at law. Any lawyer can also tell you that if you knowingly put a false statement on an affidavit and sign it under oath, you are committing the crime of perjury. Part 2 of my advice. Provide your statement as to who exactly said what and when and where, so that those who committed the crime of slander against William can themselves be brought to justice. I advise you at this time you have not committed the crime of obstructing the course of justice. However, now that it has been established beyond all doubt that a crime took place and that you were a witness to that crime, to continue to refuse to provide your testimony of the crime you witnessed will become the crime of obstructing the course of justice. This is a very serious crime, much more serious than mere slander. 3. Make the proposed remedy that William has kindly offered you. To get out of the mess you got yourself in for only $20,000 is a very, very reasonable offer. Many women go for millions of dollars in damages when they claim, quote, wrongful dismissal, unquote. I have seen many such cases myself. If you pay the very modest proposed remedy of $20,000, the next time some of your female staff come to you with slander and lies, you might just think twice about firing a man who has been working for years to reduce the amount of violence against women. Jody, it gives me no pleasure to prosecute you like this. However, if you women are ever to be capable of being considered equal to us men, you must be held accountable for your crimes. I have been hearing, quote, women are equal to men, unquote, all my life. Yet here we are. I am 49. Virtually every woman I know in the West openly condones and supports women committing crimes against men with impunity, something that you would never hear expressed in Germany, where I live. You see, Jody, in Germany, if a woman openly said women should be allowed to commit crimes against men with impunity, she would be immediately corrected and told that such a position was not acceptable in a civilized society. This is one reason I live in Germany. The women here would refuse point blank to allow another woman to commit crimes against a man with impunity because they know that would damage their own credibility and lead to violence from men should it be widespread. The very act that you not only condoned but also participated in, the slander of a man to get him fired from his job, this act is unthinkable in Germany. When a woman makes an accusation against a man in Germany, the very first thing that happens is the woman is asked to put the accusation under oath and penalty of perjury. Nothing happens until the woman agrees to put the accusation under oath. The accusation is then investigated to determine its validity. If the accusation is accidentally false, then no action is taken. But if the accusation was deliberately false, and this can be proven, then the woman is going to jail for perjury. Period. In Germany, women go to jail for what you just did. And in the US, women are rewarded by criminals in the legal fraternity for what you just did. That is a major contributor to the rapid increase in violence by men against women that you read about in your newspapers and see on your news reports every day. So, like I said, it gives me no pleasure to prosecute you in the public like this, but it has to be done, and it might as well be done by me. I am a man who has suffered greatly at the hand of a woman who committed perjury. It is only fair and just that I become the man who prosecutes women for committing crimes like slander and perjury. If you women had not supported my ex-wife in her crimes against me, then I might not have been so inclined to prosecute cases such as William's. Just to let you know, if you do decide to commit perjury and try issuing an affidavit of reply that contains perjury, I will prosecute you for your perjury. You will be charged for all costs that it takes to convict you, since you know you committed these two crimes. If you put me to the trouble of convicting you by a jury trial, I will absolutely send you the bill for all my time and all the time of the jury members. You might want to ask your husband if he wants to be stuck with those bills because you are not, quote, man enough, unquote, to admit your crimes and make very reasonable proposed remedy payment. Now, you are a woman who has claimed equality. You are a woman who is a general manager of a Holiday Inn Express. I had no obligation to tell you all this. Quote, ignorance of the law is no excuse, unquote. You are obliged to know what you are doing and take responsibility for your actions. In a phrase, be a man. Now you can decide what you are going to do. I have given you my best advice. I recommend you follow it. That will be the best course of action for you. Now that was my explanatory notes to Jody Mohn, and now this is Bill's testimony on an affidavit under oath. Okay, this is his testimony. I wrote it and I will read it because I've been the fortunate beneficiary of a higher level of education than Bill. So, lawful notice to respondent, the woman calling herself Jody Mohn, also known as Miss Jody Mohn, General Manager, Holiday Inn Express, 201 34th Avenue, Sheldon, Iowa, 51201. Fax number supplied, 27th March 2013. Let right be done though the heavens should fall. Notice to principal is notice to agent. Notice to agent is notice to principal. I, commonly addressed by the calling of William Greathouse, hereinafter the principal, in my correct public capacity as beneficiary to the original jurisdiction, being of majority in age, competent to testify, a self-realized and sentient man, my yes be yes, my no be no, do state that the truths and facts herein are of first-hand personal knowledge, true, correct, complete, not just true and correct, certain and not misleading, so help me God. This lawful notice is addressed to Jody Mohn, hereinafter known as respondent. Affidavit with respect to crimes committed against William Greathouse. 1. Item 1. Principal is of legal age and competent to testify. 2. Principal has first-hand knowledge of the facts stated herein. 3. Principal makes oath that on 27th of February 2013 he was asked to come to the office of his employer, the Sheldon, Iowa Holiday Inn Express. At this meeting, he was told that he was being fired. Principal asked for an explanation for this firing. He was told that he could not be told what the complaint was against him or the reason for his firing. He was told to call Amber. Amber gave a vague reference to videos he had released on YouTube. 4. Principal makes oath that he asked for an explanation and was denied any reasonable explanation for his dismissal apart from these vague references to videos he has published on YouTube. 5. Principal makes oath that the following weekend comments were placed on his YouTube channel that seemed to indicate that some women from his place of employment had slandered him and that this slander was the cause of his dismissal. 6. Principal makes oath that he then discussed his situation with Peter Andrew Nolan. 7. Principal makes oath that this discussion included his suspicions that he had been slandered and may have been fired from his job based on this slander. 8. Principal makes oath that the advice of Peter Andrew of the Nolan family was to pursue a lawful remedy under natural law and common law jurisdictions because the existing courts of the United States of America are a criminal cartel running in uniform commercial code jurisdiction, and there was no reasonable expectation of gaining a lawful remedy in the existing courts. 9. Principal makes oath that he decided to engage Peter Andrew of the Nolan family to assist him gain lawful remedy should that be possible. 10. Principal makes oath that in this specific matter of being dismissed from his job, Peter Andrew of the Nolan family speaks with the fully delegated responsibility and authority of principal. 11. Principal makes oath that he provided the name and contact details of respondent to Peter Andrew of the Nolan family. 12. Principal makes oath that he approved the lawful notice of 2013-03-07, which was sent to respondent by both email and fax. The fax receipt is published to the Crimes Against Fathers site. Principal is in the firm belief the lawful notice was received as it was referred to in a response from a third-party intervener. 13. Principal makes oath that he has received no response from respondent regarding the lawful notice of 2013-03-07. 14. Principal makes oath that he approved the letter dated 2013-03-17 that was sent to the email address and fax number for respondent. 15. Principal makes oath that he is in the sincere belief that this letter was delivered to respondent. 16. Principal makes oath that he has not had any reply to this letter of 2013-03-17 from the respondent. 17. Principal makes oath that on the date of 2013-03-20 he attended a teleconference between Anda and the publicly unnamed man to discuss the matter of his dismissal. 18. Principal makes oath that as the beneficiary of the original jurisdiction, he recorded this conversation so as to perhaps gather evidence for presentation in a court of law as to the cause of his dismissal. 19. Principal makes oath that the transcript of this telephone conversation presented as Appendix 1 is as accurate a transcript of the relevant portions that he has been able to make. 20. Principal makes oath that Amber and the other man participating in the conference call said the words on the telephone as closely as can be deciphered as follows. Man's voice. We have here that he was discharged due to a complaint. Was this from other employees or what? Amber. There were some employees that he had a complaint. Man. Question me, cannot decipher, of this. What was the date of the complaint? Amber. The 25th. Man. The 25th. Amber. The 25th, yes. Man. What happened? What was the nature of the complaint? Amber. The complaint was that I guessed the whole undecipherable, that some employees found Bill has a YouTube video channel and inaudible. The videos are pretty disturbing, inaudible. Man. Of what nature? Amber. Well, he talked about women. I guess that one stands out to me is women being dumped in a ditch and having he was talking about a story about inaudible, a woman who was dumped in a ditch, and he talked about how she deserved it, inaudible. Hands and her arms, inaudible. She deserved to be in a ditch, and it was pretty disturbing. Again, he has quite a few videos like that, and he is expressing and doing whatever he feels like, and he's doing inaudible. The other employees were uncomfortable, and we were inaudible, either having to let them go or inaudible. Employees were uncomfortable and inaudible, let Bill go. So although there were components of that which were inaudible, it is clear that Bill was slandered, and this was the cause for him being let go. In this sentence, in this section, which we have as a telephone recording, it is clear that Bill was slandered and then let go based on that slander. Okay? Now we can subpoena Amber if needs be. Man. So did you do an investigation to check out the YouTube site? Amber. Yes. Do you know of any reason why he would make such claims? Do you have any comments or such? Meaning, did Bill have any comments? Amber. No, there was really no against correspondence back from him. He said inaudible. He wished we would have said something to him first, but I guess you inaudible, nothing you can do, inaudible, people not being able to come forth. Man. Had he had any warnings in the past? Amber. No. Did he make any comments about co-workers in the video? Amber. Not prior to termination. After he did? Amber. Yes. Man. Okay. Man. Was any of this reported to the police then after that? Amber. Yes. Man. Okay. Now the greatest section of the transcript is included in an appendix in the document, which I won't be dictating into this video. 21. Principal makes oath that he has never condoned or supported such actions as, quote, killing women and leaving women dead in a ditch, unquote. 22. Principal makes oath that the alleged complaints referred to by Amber are lies and constitute the crime of slander. 23. Principal makes oath that the allegations by Amber that he has made, quote, many videos like this, unquote, are lies and constitute the crime of slander. Principal hereby accuses respondent of being aware of this slander during the process of his dismissal from his job and subsequently refusing to bring the knowledge of this slander to the knowledge of the principal when asked to do so in writing in a lawful notice. This accusation is the accusation of accessory to slander and accessory to wrongful dismissal based on the known slander that was presented as the reason for dismissal. 25. Principal makes oath that the United States of America is participating in unlawful, illegal, and unjust wars in Afghanistan, Libya, Iraq, and Syria. 26. Principal makes oath that he is aware that in those countries, men, women, and children are being murdered by US-supplied weapons paid for by US taxpayers. These men, women, and children are actually being left, quote, dead in ditches, unquote, in many cases. Respondent, Amber, and the employees of the Sheldon Holiday Inn Express remain silent about these murders that are being supported by their tax dollars, and therefore Amber, Respondent, and employees of the Sheldon Holiday Inn Express are actually themselves condoning, quote, leaving women dead in a ditch, unquote, and this is a fact that none of them can possibly dispute. 27. Principal makes oath that the very same act that these people have falsely accused Principal of is actually being committed by those false accusers, now known to be criminal slanderers. Principal comments that there is a passage in the Bible that might be appropriate for those who have slandered him. Quote, let he who is without sin cast the first stone, unquote. There is another passage in the Bible that is appropriate. Quote, thou shalt not bear false witness against thy neighbour, unquote. As a commandment, remember. Bearing false witness with the intent to cause injury, harm, and loss is the crime of slander. This has been considered a crime for some 4,000 years, since the writing of the Ten Commandments. There is no credible possibility that respondent was not aware of the commandment, quote, thou shalt not bear false witness against thy neighbour. This is the signature page, and it is blank on this video version because we don't want the people who countersigned it to become public, and when we place the scanned version onto the site, we will blank out the signatures. Notice of intent and proposed remedy. Based on the facts that 1. Respondent is the general manager of the Sheldon Holiday Inn Express, and the dismissal of William Greathouse could not have taken place without the full knowledge of the respondent. 2. The basis of the dismissal was the crime of slander committed by as yet unnamed parties who claimed, based on slander, they were, quote, uncomfortable, unquote, working with William. 3. Respondent has refused to respond to all efforts to request evidence of exactly who said what, when and where in the lead up to William's dismissal. So based on those facts, this lawful notice hereby notices respondent of the principal's intent. The principal now formally and irrevocably accuses the respondent with the following common law crimes. 1. One count of accessory to the common law crime of slander. 2. One count of accessory to causing injury, harm, and loss for the wrongful dismissal of William Greathouse based on slander and knowing that the slander was slander at the time of dismissal. Principal sets the proposed remedy for each of these crimes at the price of $10,000 US. Principal offers respondent the opportunity to settle this matter for the sum of $20,000. Principal offers the respondent the period until April 19th to decide whether the respondent would like to make the proposed remedy payment and settle this matter amicably. Should the respondent refuse to make this offered proposed remedy payment, principal lawfully notices the respondent that he reserves the right to impanel a de jure court and a de jure jury on the land commonly called Iowa, and will present evidence and affidavits to establish the guilt of the respondent in committing these crimes. Principal lawfully notices the lawfully notices the respondent that he will present the jury the evidence of the recording and transcript of the phone conversation with Amber and the unnamed man as the evidence that respondent must have been aware of the crime of slander and participated in the unlawful dismissal of William Greathouse from his place of employment. Principal lawfully notices the respondent that said jury will be all male on the grounds that the vast majority of females who live on the land known as Iowa condone perjury and therefore are not suitable to sit on a jury when the accused is female and the accuser is male. If women had taken the position that perjury is a crime that must be remedied, they might have had a good claim to be included on said jury to be convened by principal. Principal lawfully notices the respondent that he will ask the de jure jury to issue a remedy instruction as to the lawful remedy to be performed by respondent to bring justice to the principal. Principal lawfully notices the respondent that should respondent refuse to comply with the lawful remedy, that he will again convene a de jure court and a de jure jury and ask for an outlawry writ to be issued for the respondent. Such a writ will place the respondent outside the protection of the law. Principal lawfully notices the respondent that should respondent choose to become an outlaw and live outside the protection of the law, that no peace officers or policy enforcement officers will be allowed to provide protection for the respondent. Further, no government department nor any publicly traded company nor any private person will be allowed to provide comfort or support to respondent as an outlaw. Any such person offering comfort or support to respondent will be accused of aiding and abetting a known outlaw. This is a crime, the punishment for which will be determined by another de jure jury. The de jure court and de jure jury would be impaneled at the principal's earliest convenience. Principal again advises respondent that silence is not golden in this case. The apparatus of the state and the legal system will be no defence against, quote, the People's Court of Iowa, unquote, or indeed, as is going ahead, the Men's Business Association law courts, as this proposed new court is superior to all state apparatus. Yours sincerely, William Greathouse, human being, signed and dated, and the signed and dated version will be published. Attachment 1 is a partial transcript of recording of the telephone conversation of 20th of March 2013. I'm not going to dictate that into this evidence. You are free to read it. If Jody Mohn would like to rebut the fact that this telephone call took place, then we are quite happy to publish the telephone call into the public as well. Okay, thank you very much for listening.